Welcome to the Commercial Awareness Compass. This is your weekly guide to developing your commercial awareness in a way that goes beyond just the news. Whether you're new to commercial awareness or have some awareness already, our goal is for you to move up a level each week. So we're going to go through the beginner, intermediate, and advanced levels for you today. And we're going to break down today's story in a way that's easy for you to understand and gives you practical insights to use in your assessment centers and interviews. I'm Tori, I'm a future trainee solicitor, and I'm joined by Henry, a corporate lawyer and content creator. And today's session, we're going to talk about the merger between Three and Vodafone. So as we go through the levels, please keep an eye out for how each level builds on the last. Start by understanding the basics, and then we're getting into the intermediate levels and the advanced levels. So if we're starting at beginner level, Henry, can you please just introduce the story briefly, tell our viewers what we're talking about?
Yeah, for sure, Tori. So as you mentioned, we're talking about the recent merger of telecoms company Vodafone and Three, who have recently announced that they are merging in a 15 billion pound deal that has been recently approved by the CMA. And part of the sort of the narrative around why the merger came to light is that those two telecoms operators were arguably the two smaller ones here in the UK, and they weren't sort of sufficiently, or they were ultimately dominated by the two larger players, EE and O2, owned by BT and Virgin Media, respectively. So yeah, it's kind of a first sort of big merger between these two companies, and it's interesting to see the shift in the CMA's approach to this merger, which we'll get into as we go through the various levels.
I thought at this beginner level, we could start with a super basic concept. I think probably some of our viewers have heard of it, but just to make sure that everyone is on the same page, could you please just explain what a merger is to start with?
Yeah, for sure. So it's effectively two companies agree to ultimately merge together in terms of the service offering or product offering that they're giving. So they may exist in their own rights as separate entities and may think, actually, from a commercial business perspective, what would be better if we pulled our resources together and became one entity and moved forwards doing that. And there are a whole host of sort of legal and commercial implications and due diligence activities that need to take place for that to happen. And one of those is permission from the CMA as per this merger that we're about to discuss.
And so, yeah, you mentioned the CMA. So what is the CMA?
Yeah, so I mentioned the CMA quite a few times, and that is the UK's Competition and Markets Authority, and its kind of key role is effectively to sort of ensure that when these sort of mergers happen, that ultimately this is permitted, it's within the legal realms in sort of the regulatory remits, and that consumers ultimately won't be impacted unfairly as a result of any mergers.
Gotcha. So really, at this beginner level, if we're thinking about what are the kind of areas of law that are engaged, competition law definitely seems to be one that is relevant. And I thought it would be interesting if you talk more, because you were saying about how competition law, part of it is kind of protecting consumers. Or could you just explain a little bit more about competition law generally?
Yeah, sure. So there is, of course, the CMA when they're looking at these mergers, when organizations of a certain size want to go ahead with a merger, that there's a whole host of sort of regulatory requirements that they will need to comply with. And we've seen that the Competitions Markets Authority generally takes quite a sort of strict approach to saying this test needs to be satisfied, this, and this. So when we're looking at this merger, it's quite interesting to see that they've kind of taken an approach that's more consumer focused, ultimately allowing these two telecoms entities to merge should, in theory, benefit consumers. But to allow this merger to happen, the CMA has said this can happen, but actually it will only be able to happen if certain conditions are met once this merger goes live. And we'll talk about these shortly, but a lot of these conditions that have been implemented are ultimately to benefit the end consumer.
Okay. Nice. Thank you so much. Was there anything you wanted to add on this beginner level before we move on to intermediate, things that our viewers need to understand about this story to be able to reflect on it?
No, I think we'll build nicely as we go up through the levels on the points that we've just spoken about in more depth.
Okay, sounds good. So let's move into the intermediate level then. And I think, yeah, something that sounds so interesting with this story, as you've alluded to, is these kind of conditions that the CMA has stated. Did you want to say more about that?
Yeah, for sure. So as we just briefly touched on, to allow this merger to go ahead, there are a number of conditions that they imposed. And it's important to note, actually, that depending on the type of merger that goes ahead, different conditions may be imposed, or there may be different things that the CMA is looking at in the scope of the regulatory remit, which of course will be our job as lawyers, competitions team, and the various other teams that work on such transactions at the firm to advise our clients on and say what the likely risks are of this merger, or sort of the market implications. And equally, actually, that say a merger is about to come to a head, say your firm is advising different telecoms companies what the impact of any potential merger may be. So whilst there are two parties in this one, three, in Vodafone, actually, if you're a smaller telecoms provider, or you're, I don't know, let's say O2, you'll need to advise your clients also that this is coming up. This could be potential implications of that for you. But yeah, in terms of the points that the CMA have flagged, so they've, as we mentioned, they focus around sort of consumer benefits. And one of them is that the merged entity needs to provide like a unified 5G network, access to 5G. So many of us are now remote working, or working on the go, we're sending emails on the tube, and we're seeing more and more access to these sort of 5G networks. So the CMA have said that this new telecoms entity has to provide appropriate download speeds and reliability across the UK. And one of the other ones we mentioned briefly about the smaller telecoms companies, those such as sort of giffgaff or Smarty, which kind of vibe off of the big networks, is that this new merged entity needs to still work with these smaller operators, make sure that they've got fair terms, and not kind of sucker punch them off the back of this merger coming ahead and sort of hiking up costs and changing contract terms. They still need to support them, because then in turn this actually provides more support and options for consumers to have a sort of a broader range of networks to choose from.
Mm-hmm. Okay, thank you. And I was also wondering, kind of what would the legal teams look like who are working on this? Like, you mentioned a little bit about some of the legal issues that can arise, but yeah, I just wanted to hear more about what the lawyers are really doing in this type of instance.
Yeah, for sure. So we'll have the competitions team focusing on basically getting the deal through, getting it to the CMA, and sort of answering any queries that they may have, any challenges they may have. But then if we say merger's successful, post-merger, there are going to be a lot of things to do. And that can involve sort of contracts that each of the separate entities may have had with suppliers. They're going to need to be renegotiated or discussed. There are going to be, both of those entities have employees. What happens to those employees? Because there's likely to be some duplication of roles. Are there going to be redundancies? How does that happen? And also, both of those companies in their own rights own intellectual property for their businesses. What then happens to that intellectual property? Is it owned by the newly merged company? There's going to be new intellectual property that emanates from this merger. Who owns that? So when you guys, those watching, are sort of entering the sort of the practice of law, you're entering your law firms for your training contracts and your careers, whilst you may be a litigator, a corporate lawyer, a property lawyer, whatever that may be, you will still be working with various other departments across the firm, which is great because you get exposure to broad topics in projects, and you also get to work with different people. So don't think that if I become a property lawyer, I'll just be siloed. You'll very much be working on projects firm-wide.
Thanks so much. That's such a useful insight to think about as well, about how, yeah, even though a firm might have a mergers and acquisitions team, it's not that that's the only team that would be engaged or have anything to think about when it relates to a merger. I was also thinking, as kind of a general question for our viewers, well, for you, for our viewers, is because I think it's great that you chose a merger for this topic, because I think mergers frequently do come up in assessment centers as a case study kind of thing. I think a merger is a really common case study to see. So I was thinking, if I was in an assessment center and I received a case study about a merger, what are the kinds of questions that I would ask myself, or what are the kinds of considerations that would be relevant? I think you've done a great job already, I think, outlining a lot of the things that are relevant here. But I just wondered if you could speak more to that, of when you saw this story, what are the questions that you asked? What are the things that were flagged to you?
Yeah, I think you're completely right that I'm casting my mind back to assessment centre days, which was quite a long time ago. And you're right that they do come up quite frequently, and equally in sort of when I was doing the LPC business module, mergers and acquisitions came up quite a lot. So I think obviously regulatory approvals is a huge thing to think about. And of course, sorry, each assessment centre question is likely going to sort of draw on different areas. So you need to make sure that your response is tailored specific to that individual scenario. But things like making sure regulatory approvals are in place. What's the funding going to look like? How is this merger going to be funded? Is one company buying the other? What's the structure of this looking like? We spoke about it earlier too in terms of intellectual property. What's happening to the ownership of that? What's the actual service that these companies are providing? What's happening to the data of, say, let's just take Vodafone. Vodafone has a lot of personal data. What's happening to that? What are our obligations around notifying clients? How is that clients being sort of consumers? How is that being communicated to them? So there are a whole host of things from a litigation perspective as well. If you've got two huge companies that are looking to merge, you are likely to get challenge from perhaps other people within that sector, saying, why is this allowed? This is going to impact us this way. That's unfair. And just the various sort of tests that need to be satisfied to say, actually, this merger shouldn't go ahead.
Thanks so much. That's so useful. I can imagine myself, if I had an assessment center coming up, I would just be taking notes as you say that, of the different things to think about. I was thinking maybe we could move on to advanced, unless there was anything else you wanted to add at this intermediate level.
No, but one point that did, sorry, not specifically around this point in terms of the story, but we spoke about working with the various different departments such as employment, competition, corporate. And one key point around sort of working with those different teams is also the importance of soft skills, and just being able to sort of approach different people within various different teams to ask for their support, or kind of just working with a broad range of people. And I think it's a really good skill to sort of start honing and working on now at this level. So when you ultimately step in to your sort of law firms, you have that level of confidence and comfortability with going up to various different, say perhaps a trainee in a different department that you need to work with, and kind of building that for yourself now, so you can kind of hit the ground running when you get there.
Thanks so much. I think it's always useful for aspiring lawyers to get more insight about the kind of skills that they really will need. And it's worth, knowing that now, so you can invest the time on building those skills in advance. So if we move into the advanced level, I have a couple of questions, but also just happy to hear from you about what comes to mind. My first question was really just about what's next. So you mentioned, so there's this CMA approval that has come in. Basically, what's next for this merger to happen? How are the lawyers involved at this point?
Yeah, for sure. So as we've said, the merger has kind of got approval, subject to certain conditions being met over sort of however long the parties have agreed. Off the top of my head, I cannot remember. But there are going to be a whole host of things that now have to happen. We've got the approval, but now what? What do these parties now actually have to do to move this forward? And one of those things will involve, we touched on it earlier, be around engaging the employment team and working out what's happening with all of these employees, because we've got a lot of them. We perhaps don't need all of them. Are there going to be redundancies to be made? And the new entity will need to be advised accordingly on what the process is in terms of making people redundant. How do we do that? What the relevant criterias are. So that's going to be one job for the employment team. We're also going to need our commercial contracts team to start reviewing all of the contracts the entity has with its suppliers. There's likely to be a lot of crossover in terms of supply contracts that Vodafone and Three both had. Probably don't need both. What do we do? Do we terminate these contracts? Do we renegotiate them? And again, there'll be a whole host of commercial considerations that will need the client to be advised accordingly in terms of negotiating those contracts. We're also going to need our data team to be involved. We touched on that earlier as well in terms of any data privacy, systems integration, how are we going to move this sort of data around. And also from a sort of technical perspective, this is a telecoms company. They do telecoms stuff in terms of connecting individuals to networks. That's going to require a lot of sort of systems integration and configuration. So we're going to need sort of those teams to also kind of work on that. So that's kind of the business side of things. We're also going to need the lawyers to not only look at the commercial supplier contracts, but also the contracts that we being the client has with the end user, you or me, who are using our phones and we're using this network to kind of access whatever it is we want to access on our phone. So what does that agreement look like? Again, Vodafone and Three probably had similar, probably but slightly different contracts with their end users. Do we just get the lawyers to merge the two terms together? Do we want to kind of rethink how we do that? But in doing so, the CMA also require that, or consumer laws even need to ensure that any information that's being passed to the end user is clear, it's communicated within time, it lets the end user know what's happening. Do they have a choice? Can they leave? We want to make sure that we're not in breach of any of our own obligations, like from the get-go. We want to make sure that we're doing everything from that we have to comply with the relevant laws, and that's what's our role as the sort of lawyers to let them know to do that.
Thanks so much. I think that this outline is showing so well how or why case studies often are about mergers, because there just is so much to discuss, so much to think about. It sounds like a lot of work for the legal teams.
Yeah, I completely agree that there is so much to think about, and when you're sort of in practice, usually you'll have access to like a data room where all of this information is sort of collated and put together. There will likely be sort of somebody who's running the deal who has like a sort of checklist almost, so you can satisfy all of your pre-completion obligations to make sure that X, Y, and Z have been achieved before the deal is completed, or they're usually like conditions precedents, that conditions of the deal going ahead. And then also post-completion, these are all the tasks that happen sort of post-completion. And quite typically, that's a big trainee task. A lot of those post-completion things to file relevant applications at the relevant sort of offices, and all of those tasks that need to be done. And having that is a good way for the lawyers to keep track of what's going on, because you can't really drop the ball on a big merger like this.
Yeah, and thanks as well for highlighting what would be a trainee task. I think for aspiring lawyers, it's always helpful to see actually what's the type of work that you specifically would be doing as a trainee. I had one other question for you, because you mentioned something earlier about basically third parties, so like other telecoms companies that are not party to this merger, what are the kinds of things that they're thinking about? And I thought that would be good to expand on at this advanced level, because at this advanced level, we're really thinking more big picture, strategic thinking. So I think it's worth giving some time to what other telecoms companies might be thinking about, if you want to expand on that.
Yeah, for sure. So both of those networks existing in their own rights as separate entities likely had smaller sort of virtual networks, sort of piggybacking off of their sort of main lines. And they will still need access to that sort of network to continue operating. And they will want to know that we will still have access to sort of this network when you merge, because otherwise we can't exist. And we have a plethora of consumers that use our data. So they will want to consider their contracts that they have. So say, for example, I'm a small network. I've got a contract with Vodafone to have access to their data networks to provide to my consumers. What's that going to look like post-merger? This will be a time, and it's going to have to be sort of renegotiated. It's going to have to be sort of negotiating sort of just fairly, because that's something that the CMA has advocated, that one of the conditions is that this new merged entity works closely with the small network operators, because that again achieves this goal that the CMA is focused on around making sure that consumers are protected, consumers have choice. So yeah, they will again need their own sort of legal advice just in terms of negotiating that contract.
Nice, thanks so much. I also think that illustration is really helpful to see a little bit more of how the telecoms industry works. And I think with commercial awareness, what's cool is, so when I first started trying to develop my commercial awareness, I found it daunting in the sense, like, I thought that required me to be an expert in all kinds of different businesses. And I would say that that's not the case, because today we're talking about telecoms. Last week we were talking about social media apps. Neither of us, I think, are tech experts. But I think it's cool because commercial awareness, developing that, really gives you that opportunity to be curious and to learn a little bit about how these businesses run, because definitely it seems like understanding just the basics of the telecoms company or telecoms industry is actually important to understanding some of the considerations with this merger.
Yeah, I would wholeheartedly agree in terms of commercial awareness is so much more. I think it's one of those terms that is bounded around quite a lot. And as you said, Tori, it can be quite daunting. And I think for me, considering it, when somebody says, how do I become commercially aware? I think it's just looking at a business story, as we've done a number of times now together, and just thinking, so what does this mean for the client? What does this mean? As we've got this story here, there are so many things that you can unpack from it. It's not just a merger has happened, that's a merger team thing. It's a litigation, it's an intellectual property, it's a data protection, it's a cybersecurity, it's a commercial contracts thing. And so if you look at any story or anything that you read in the FT, BBC News, wherever it may be, there are going to be things that you can think, oh, I wonder how this affects that, or I wonder what happens with that. And when you sort of drill down into these things, you actually think, oh, there are so many things that can be said about this topic. And I think you're completely right. It's going into it with sort of a curious mind. These law firms all have different departments and different lawyers that cover different topics. A lot of them will be working on the same projects, but from different perspectives. And I think it's, say you're applying for a firm that deals with X, Y, and Z, these are its specialities. If you've got a business story in mind or a commercially aware story that you want to think about, get that story here, look at what the firm does and kind of map out, okay, so this is the story. How do I think this team would be involved in that? How do I think this team would be involved in that? They may not have any involvement at all, but if you can start thinking in that way, then when it comes to analyzing any story, if you're given a story on the day of your assessment day to consider, you've kind of got that sort of analytical mindset ready.
Yeah, that's so perfect. Thank you so much. I don't think I have any other questions for you, unless, was there anything you wanted to add about the story or about commercial awareness generally?
Nothing springs to mind. So if you've got anything, feel free to hit me with them. If not, I think think we've covered quite a lot.
Yeah, and honestly, I love the way that we're concluding, like what you just said about how this commercial awareness, developing it really is about developing that analytical mindset and your curiosity. That's so true. And I hope that this episode has been helpful to our viewers at showing you there's so many different things that you can consider if you're dealing with a case study or you're asked about a recent news story in your interviews. So thank you so much for joining today for Commercial Awareness Compass. Remember, as always, commercial awareness is more than just staying on top of the news. So you really need to be considering why these events matter to clients, how you as a future lawyer could be involved, how you could provide strategic value. And as we've talked about already, it really, really is about that curious analytical mindset. And as I think that today has demonstrated in other episodes as well, I think developing your commercial awareness is fun, actually. There's lots of interesting things to think about. It doesn't have to be daunting. It doesn't have to be scary. It can be fun, and it can be just a nice conversation with someone about like what's going on in the news. So as you're trying to develop your commercial awareness, always ask, how does this impact clients, and what would a law firm be doing to help? So keep that mindset with you as you're going through your interviews, your applications, and join us next week to keep developing your commercial awareness. Until then, prepare without the panic.